Just how long after an election should ballots be accepted to be counted? At what point does an individual attempting to enter the U.S. get to claim asylum? Plus, headlines from across the country with America's talking, and we delve deep into calls for transparency of the Chicago Teachers Union. This is the Center Square Daily for Tuesday, March 24th, 2026. I'm your host, Greg Bishop. In several states, mail-in ballots postmarked on Election Day can be counted after Election Day for up to 2 weeks, like in Illinois, or up to 5 days, like in Mississippi. Several legal challenges of such laws working their way through the federal judiciary. The Supreme Court recently ruled in favor of Illinois Congressman Mike Bost's standing to challenge Illinois' law allowing Election Day ballots to be counted for up to 2 weeks after. But again, that was on whether Bost had standing to sue. Now, the justice's ruling in that case was not about the merits. Monday, in Washington, D.C., the Supreme Court heard Watson versus RNC. That's a case challenging Mississippi's deadline for mail-in ballots to be received 5 days after an election, as long as the ballot was postmarked by Election Day. A lawyer representing Mississippi, Scott Stewart, he defended that state's election law in front of the justices Monday.
The dispute is whether Congress blocked just one change, allowing ballots cast by Election Day to be received after that day. States have allowed that for over a century. Congress has respected it. No one challenged it until now. Mississippi satisfies that rule. It makes a choice on Election Day. And only that rule respects the last 180 years of state lawmaking. If Election Day must be what it was in 1845, that takes out much more than the ballot receipt laws of 30 states today. It dooms absentee voting, modern methods of voting, the secret ballot, and more. Congress did not adopt that destabilizing view when it simply set the Election Day. The Fifth Circuit was wrong to rule otherwise. This court should reverse.
Paul Clement, a lawyer for the Republican National Committee, he showed how there could be problems with allowing mailbox postings after the polls officially close on Election Day.
The main mailbox, post office in Chicago stays open 24/7. So when all the other polls close in Illinois or every other state at 8 p.m., the post office is still open till midnight. Now, I'm not here to say that there could ever be voting fraud in Chicago, but the possibility that there's a 4-hour window where people could go get their ballots, absentee ballots postmarked after all of the returns are in, and they know that, oh, this is the election where these things could turn the result.
Always interesting to hear a little bit of levity coming from the courts and the gallery. But some justices on the courts, they appeared skeptical of such laws. 14 states and the District of Columbia allow domestic mail-in ballots to be received after Election Day. Justice Clarence Thomas, he questioned what the filing of the filling of the ballots and handling of those and giving them to an election official after elections are closed is a questionable act. Justice Amy Coney Barrett agreed and challenged the historical precedent of ballot receipt deadlines. Justice Neil Gorsuch also appeared to agree. He posed a hypothetical where a candidate running for office calls on voters for the opposite candidate to revoke their mail-in ballots before they're counted after Election Day when the candidate undergoes a serious scandal. Some of the justices expressed disagreement about the strict Election Day deadline for a ballot to be received. Justice Ketanji Brown Jackson questioned whether Congress intended to set a hard deadline for ballot receipt when it designated a federal election day. Now, on the issue of absentee ballots, Clement, representing the RNC, said there are ways to work around that with a strict Election Day standard.
I think one reason that they've done it is some states do want to accommodate overseas or military voters. I do think that there are other ways to do that than the ballot deadline, as I've talked about, and I think Mississippi's voted with their feet. I don't think anybody's going to be disenfranchised in Mississippi when you can vote. If you're overseas, you can vote by email. So I think Mississippi solved that in a much more targeted way.
Now, citing a recent poll from CRC Research for Honest Election Project, the RNC Election Integrity Communications Director told the Center Square that 83% of voters across the country agree mail-in ballots should be in by Election Day. and 78% said it makes elections more secure. Now, election law, not the only controversy justices are having to contend with. We could get an outcome in that case this summer. Tuesday, they also heard a case around at what point an individual attempting to enter the United States can claim asylum protections. Joining us to discuss this is the Center Square Princess reporter, Andrew Rice. Andrew, thanks for taking time with us. It's a deep issue impacting a fair amount of people in the country, and there's also a lot of politics involved here. Give us an overview of what this case means and what justices heard today in court.
Right. Well, thanks for having me, Greg. This case is a hugely consequential one, as you said. Asylum is a big issue going on, and how it is processed in the United States is a big issue that's going on. Just getting out of the arguments earlier, reporting on those arguments, there was clearly a partisan and political divide. A lot of justices, some of the justices appointed, more liberal justices, clearly were wanting to side with this immigration advocacy organization that was arguing that if you are on the Mexico side of the U.S.-Mexico border, you should be entitled asylum protections. Really, it got all to the heart of this 1990 Immigration and Nationality Act that says once you arrive in the United States, you are entitled to asylum protections, and you're entitled to a hearing with an immigration judge and going through that official process. And some of the liberal justices clearly agreed with that, or appeared to agree with that in the arguments today. But there was definitely some pushback from the other side of the aisle, and a lot of justices were looking to define at what point does arrives mean. At one point, even Justice Gorsuch said, if I'm halfway across the Rio Grande, does that mean I've arrived in the United States? That was a really salient point that really showed how are we defining this term from a statute from decades ago, really. And it will have a dramatic impact on how we look at asylum law and truly just the definition of arrival in the United States moving forward.
Yeah, and what exactly is asylum, and what words can people be told to use with border officials to be able to get asylum status? There's obviously a lot of nuance here, Andrew, but you were outside the courts when some demonstrators were on the steps sharing their perspective. Nicole Ramos, director of border rights at the Border Rights Project, she argued for it to be a humanitarian issue, one that takes a look at just exactly who is looking to get asylum and who would be cut off if the Supreme Court sides with those who want stricter asylum guidelines. Here's that clip.
We cannot be a people that says never again if we enforce policies that make death inevitable. We cannot be a country that espouses family values and to protect children when we let them die on our doorstep. We cannot be a country that professes to be one of laws and human rights if we allow a president and administrative policy to dictate who is desirable and who will be allowed in to grant access to the only legal process that can save their lives. Asylum is not a loophole. It is not a trick. It is the only legal process available for refugees to save their lives.
Again, an advocate on the steps of the Supreme Court just before the justices started hearing arguments, seeming to take a bit of a humanitarian approach to this. But you also had others who were sharing somewhat of a spiritual perspective. Here's Abi Janamanchi with the United Universalists Association. He's a reverend, and he shared his thoughts on how this idea is not just a one religion idea. Here's what he had to say.
People of faith and faithful people across traditions, Hindus, Christians, Jews, Muslims, and the occasional Unitarian Universalist as well. People who just know better, standing together. The brief that we all signed says what our traditions have always taught. Safeguarding and protecting the stranger is not an optional thing. It is at the heart of everything that calls us to practice radical hospitality, not just for individuals, but for whole societies.
Andrew, these are two perspectives. Were these brought to the court this morning? Were these things that they argued, or did we get more into kind of the nuance and the legalities of this question?
Right. That's a great question, Greg. Truly, in the arguments, there was not much talk about this this idea of hospitality and needing to speak to a sense of faith and speaking to a sense of a desired goal based in religious tradition. Really, the justices and the lawyers representing both sides of this issue were focused on the legality of the issue. They were focused on what does it mean when someone is said to arrive in the United States? What does that definitional language mean? And the justices were really focused on that. There was not hardly a single appeal to the more emotional and humanitarian aspects that we saw in some of those clips. Really, it was a large focus on what does this definitionally mean? How did the statutes that have stated you are entitled to asylum protections when you arrive in the United States, how does that apply to the modern day when people are coming up to that U.S.-Mexico border or any other port of entry in the country?
It's fascinating, again, to kind of see, on the streets, you hear about the humanitarian issues, you kind of have the tugging of the heartstrings, so to speak. But when it gets down to the nitty-gritty detail, it's about the legalese and how to interpret these laws. And in courts, a lot of the times, Andrew, I'm sure as you're seeing as reporting on the U.S. Supreme Court, they don't really, give lane to that emotional side of things. They seem to just stay in the lane of this is about the law, this is about our interpretation of the law, and we can't let emotion get involved in that. Andrew, what's next with this case, but also the case that we talked about to open the show with that you also reported on yesterday concerning election law? Give us kind of a timeline. When can we actually see some outcome of their opinions in these cases?
Yes, absolutely. Well, these are two very substantial cases, and it is kind of a surprise that the court is hearing them at this point in the term because the Supreme Court's term will wrap up at the end of June. Typically, they try to have all their opinions and decisions out by the very end of June so they can recess for July and August. However, there have been some exceptions in recent years when you have very substantial cases that reach into the very beginning of July. But the justices will have to make a decision on this case in the next few days, really. This case and the election law case that you mentioned earlier, these cases in the next few days, and start writing briefs and start applying the existing law and new law and have those decisions out by June. And I even heard this in the case today. Some justices really wanted that clarity on the arrival, on what that arrival means, because they know that lawsuits are going to come after they issue a decision in June at the end of their term.
Something else about the courts, it seems like some of these cases don't actually end at the Supreme Court. Sometimes it just opens avenue for other lawsuits in the lower courts, and we may actually see this or similar questions brought up in the future. But as we await a decision in those cases and plenty of others, Andrew, it seems that we do have a decision on a case that impacted the Center Square directly when it comes to requests for open meetings information. Tell us about this case.
Right. Yes, exactly, Greg. This case affected in a big way affected the Center Square. The Center Square has been litigating this case over the past several years over and allowing public and press access to meetings of the Tennessee Judicial Advisory Commission. They apply practices and procedures. They give recommendations to the Tennessee Supreme Court. And so we filed this lawsuit because back in 2018, the commission they sought to stop these meetings from being public due to a disruption. And so the Center Square filed a lawsuit, and ultimately, the meetings have remained closed throughout litigation, throughout years of litigation. However, once the Center Square applied petition up to the Supreme Court seeking a relief in this case, seeking to open up these meetings to the public that were, according to court documents and the record, open for 35 years prior to their closure in 2018. We petitioned to the Supreme Court, but were unfortunately denied on Monday. We're denied, and that's going to be something that we're looking for kind of a closure to.
Some
as
kind
I
of
use the
resolution,
word.
right? Yeah, it's one of those things where as reporters, we have to use public records laws sometimes to get information, and sometimes there are roadblocks. And when there are roadblocks, take it to court to see what the legalities really boil down to. Well, Andrew, greatly appreciate your reporting. We'll definitely keep an eye on what's going on at the U.S. Supreme Court, and you and the team with the Center Square are on top of that. Greatly appreciate it. Now it's time for America's Talking, with headlines from across the country that you can find at thecentersquare.com. Colorado's Democratic-controlled General Assembly poised to send several gun control bills to Governor Jared Polis roughly 2 months into the legislative session. The Center Square contributor Derek Drapin, he reports the House is expected to hear on third reading this week Senate Bill 26046, which would require all purchases of gun barrels to be made in person at a firearm dealer. Now, last week, House lawmakers approved legislation to expand that state's red flag law and require strict permitting requirements and security measures at gun stores. Another bill that would ban using 3D printers to make firearms or components and criminalize possession of digital instructions is scheduled for a second reading on the Senate floor Tuesday. I've already seen questions about how you can go about the First Amendment protections of blueprints for 3D printer schematics. We'll see how that plays out in Colorado. Democrats there arguing the bills are aimed at reducing gun violence. Republicans arguing that it chips away at Second Amendment rights to keep and bear arms that the Second Amendment says shall not be infringed. Meanwhile, the bill would also require firearm dealers to keep sale records of barrels for at least 5 years, and that bill was scheduled for third reading Monday. In other news, at thecentersquare.com, you can find by getting it in your inbox. Go to thecentersquare.com and sign up for that newsletter daily. You'll get those headlines. Meanwhile, a group of Washington sheriffs urging Governor Bob Ferguson to veto sections of Senate Bill 5974, and they're still waiting to find out if their concerns will be addressed when the bill is signed into law. The Center Square Associate Editor Carlene Johnson reporting the highly contentious bill would require county sheriffs and police chiefs to meet new eligibility requirements, which include having at least 5 years of full-time law enforcement experience and not having done or said anything that would get state certification revoked by the Criminal Justice Training Commission in Washington. That commission could revoke certification for misconduct, leading to elected sheriffs being removed from office. Mason County Sheriff Ryan Sperling said his constituents still asking a lot of questions about the bill.
I hear politicians say things that aren't necessarily true all the time, yet they're not necessarily held accountable. But sheriffs are in a different category according to a lot of people. So that's one of those things that they're wrestling through. Should sheriffs be political? Should we be able to say, or should it be controlled? And this bill effectively will mute sheriffs because of the threat of being decertified and removed. If my constituents are pushing me to stand up against something that Olympia is doing, I'm going to speak out, or depending on the level or the degree, we're going to say something, and this is going to potentially stifle that and again control the First Amendment rights.
The letter Washington sheriffs sent to the governor, signed by Sheriff Sperling of Mason County, Sheriff Clay Myers of Kittis County, Sheriff Mark Sider of Walla Walla County, and Sheriff Brad Mankey of Stevens County. Federal law enforcement officers, they've joined Transportation Security Administration workers at O'Hare International Airport in Chicago. The Center Square's Jim Talamonte reports ICE agents were seen at O'Hare and several other airports around the country. More than 400 TSA employees have left the department, and thousands of others are missing work, while a lapse in federal funding leaves them without paychecks. American Federation of Government Employees Local 777 told the Center Square that TSA workers are concerned. They said at the end of the day, they've been loyal to aviation and protecting the flying public, and all they're requesting is to be paid, not to be replaced. When they see individuals assisting them, the union said it gives union members the thoughts that they're trying to get replaced instead of trying to keep them on board. The union said their members would have another issue in April when rent and mortgage payments are due for a second month, since they were last paid February 13th. President Donald Trump was asked Monday if he would consider giving $10,000 bonuses to TSA workers who do show up on the job, even during a partial government shutdown, as he did last year. He said it could happen. He also went on to blame Democrats for the lapse in funding for TSA workers. Still no resolution there on whether or not you're going to see a bill pass Congress to fund DHS. Meanwhile, the federal government is the one who should control hikes in gas prices, according to Democratic attorneys general from across the country who blame the Trump administration and the U.S.-Israeli conflict with Iran on surging gas prices. The Center Square regional editor Dave Mason reports Attorneys General Rob Bonta of California and Kwame Raoul of Illinois made the comments late Monday morning when the Center Square asked them what their states could do to limit the jump in prices. They said that it is the Trump administration who initiated the conflict with Iran. Attorney General Kwame Raoul called the conflict, which he noted was started without congressional approval, another federal action that makes life less affordable. Californians, who consistently experience the nation's highest gas prices for several years, even outside of international conflicts, saw an average of $5.79 at the pump Monday. According to AAA, Illinois' average price for a gallon of gas, $4.17. For both states, that's an increase over $1 a gallon since 1 month ago. Both prices are above the national average of $3.96 a gallon, which is an increase of slightly less than $1 a month. Illinois and California also having the state's highest gas taxes. The White House telling the Center Square that stressed gas hikes are temporary. The president has said temporary pain for long-term gain. And that's America's Talking, with headlines from across the country that you can find now at thecentersquare.com. We'll be right back. Welcome back to the Center Square Daily. I'm your host, Greg Bishop. Now let's get Illinois in focus, with a Cook County judge denying a Chicago Teachers Union motion for summary judgment and granting a plaintiff's request to compel discovery over the union's lack of releasing financial audits to its members. With more on what this means for Chicago Teachers Union members, the school district, and taxpayers, let's now talk with Ángel Valencia, senior counsel at Liberty Justice Center, who represents the plaintiffs in the case. Ángel, thanks for taking time with the Center Square Daily. What is this case all about?
It's good to be with you. So this case is essentially a lawsuit that was filed by a group of employees, all members of the union CTU, in which they basically claim that the union was not complying with their contractual obligation of producing yearly audits to its members. It had not done so for a number of years, and this group of employees had no option but to file suit to enforce this contractual obligation.
What are in these documents that union members are hoping to see?
Well, we'll have to wait and see what they get to see, but the audits, the full unabridged audits that the union must provide its members, give us a look behind the curtain, right, as to the union's expenditures, what they're spending, what they're investing their money in. And remember, this is money that these members pay into as a portion of their paycheck. Members of the union pay money to CTU for CTU to represent them in collective bargaining. So CTU is essentially the agent of these employees when it comes to negotiating things like better work conditions, pay raises, etc. So it's just a question of accountability and CTU living up to its contractual promises.
How did we get to this point? From my understanding, it's been like 4 years worth of financial audits that just have not been released. Now a judge is saying, hey, we're not going to dismiss this case. We're going to compel you to discovery for the layperson, meaning you've got to show the goods. How did we get to this point?
Right. So, as I said, CTU just failed to live up to its contractual obligation, right? So it did not show these audits as it was supposed to do. So our clients, the plaintiffs in this case, had no option but to sue, right? To enforce, to try to enforce the contractual a duty here from CTU. So what I can say is that, you know, this was a huge win that we got yesterday on behalf of these employees, and now we're going to get a chance to conduct discovery and see what the union has. You know, what how CTU has been spending the employees' money.
You know, that was kind of my next question here is what's next? Is that all the members are looking for is these audits, and does discovery satisfy that?
The members are looking for these audits that were not produced, but they're also seeking to secure a commitment from CTU to comply with this obligation going forward every year. So this is not just a question of having a past look at past audits that were not produced. It is to also to secure that commitment that is already a contractual obligation from CTU to produce these audits going forward. And without getting into the legal strategy here, we are going to conduct requests for discovery, and we will see what we can uncover, right? So,
how important is this kind of transparency beyond just this case, right? How important is this kind of transparency for, you know, union members who are paying dues, for parents, for taxpayers, even of the school district? How important is this transparency?
It's huge. It's huge because these teachers, these employees are paying the union to represent them as their agent when it comes to matters of collective bargaining and negotiating for better wages, better benefits, etc. Right? So this is their livelihood, really. This is their you know, this is their job. So really, it matters a lot to these employees and to these members of the union, because at the end of the day, they're paying the union. So all they are asking for is accountability and transparency here from the union to see how and where their money is being spent.
Ángel Valencia, Senior Counsel with the Liberty Justice Center. Greatly appreciate you taking the time. We've been on top of this story and appreciate you guys keeping us posted, and we'll see exactly where this goes as the Chicago School District, one of the largest school districts in the country, right? I mean, if you've got the union representing members, not really showing how the union's using those dues, that could impact political decisions at Chicago City Hall and beyond. We'll definitely want to stay on top of this, so appreciate your time here for the Center Square Daily. All right, from my studios in Central Illinois, I'm Greg Bishop, and you can join us back here Wednesday for more stories impacting you, the taxpayer, from across the country, only with the Center Square Daily.